There we
Thank
go.
you, Mark. Thank you, Mark. And
Susan, you didn't want to
so
record yourself? You didn't want to record yourself, huh?
generally never record interagency meetings. Never, never, never. I think the commissioner is the commissioner on?
Yes, the Commissioner Kim is on.
Okay, Commissioner Kim.
He may be on mute.
Well, that doesn't help. I don't see him.
Make sure that you hit okay on the recording. Maybe that's why. Not sure.
I heard the commissioner.
Oh, you did? I didn't.
No, he's silent.
Susan, if you're the host, you can click on a button above the commissioner's left ear.
I don't see him, but I don't see him.
He may have logged off and it's going to log back on. Just
here he's coming back on now.
Okay, if you go to participants, you can click on ask him to unmute, and then he has just a button to click on.
But I'm okay. Here he is.
Yes,
hello,
I'm
Commissioner.
back.
All right.
Hi. Well, welcome back. So I've kind of introduced that our meeting and said we were going to start with a few words from you.
Well, thank you so much, Susan, as always, for your leadership with all the community board work. It's so important. And thank you, Susan and Celeste, for organizing today's meeting so that we can explain a little bit more about our innovative MEND program. I also want to thank Judge Kramer and Hallie from Oath for putting together today's presentation and administering the MEND program. Personally, I've been a community board member, CB5 in Manhattan. I've been a former state liquor authority commissioner. I'm in this role now to help small businesses. And back in 1993, I became a certified community mediator through the Brooklyn Mediation Center. And so when I put back all of my experiences into one, I can't think of a better way to kick off what we're trying to do today. We live in a city, 8.5 million people with 10 million opinions, as the mayor likes to say. And we know that nightlife establishments can present unique challenges to the community boards. And so we want to really be here just as a resource. The Office of Nightlife under Jeffrey Garcia is really taking a strong leadership position on this to be a resource, to be that mediation resource for the community boards and these businesses that are just trying to make a living. So understanding all of that, I just, again, want to thank the community board district managers for being here today. And Susan, we go way back. And so all of the things that you've been continuing to do to keep improving relationships between community and government and the businesses, I can't thank you enough again. With that, I'll just turn it over to our Deputy Commissioner, Kitty Chan from our Division of Business Services. And she's just going to review some of our free resources, and then we'll get into the MEND program as well. But thank you all so much again for your partnership, and we continue to look forward to working with you. Thank you.
Thank you, Commissioner. And thank you very much, Susan, and everyone for letting me come here today to talk about some of our services. As Susan and I were chatting earlier, and she said, there's been on and off again relationship with SBS. Just know we're here to help you. And I'd want to just go over really quickly some of the services that we provide so you're aware that, our basic services, business education, financing assistance, business consultation, MWBE certification, recruitment, training. But, two of the things that we have that you may be really interested in is a legal assistance. We have our pro bono legal assistance program, but we also have our commercial lease assistance program, which actually we offer free clinics if any of you would be interested in hosting one in your community. What we do is we'll come in and we'll bring in our lawyers and we'll help work with them to read through the leases, help explain it to them. And this is whether or not they're already in a lease or they're thinking about signing a lease or there's some situation with their lawyer. We also have our NYC Best, our Business Express Services team that provides help navigating government, but also our NYC Best in Your Community program. We will work with you to actually walk the corridors of some businesses. And what we do is we do a compliance consultation to ensure that a business is as compliant as possible, right? And prepare them for an inspection. We believe in education first, right? And that's one of the most important things that drive our services. We believe in educating business owners and entrepreneurs so that they can make informed decisions on how they're going to move forward. One of the things that we've actually built for in order to work with all of you better, and we will be sharing this with you in the coming week, is I'm going to share screen for a second, and it's this online. Okay, we built this online. I hope it's on screen. Okay, we built this online tool to make it easier for you to refer businesses to us, right? And what we did was we are only sharing this with our partners. It's you, the electeds, our CBOs, our bids. And what we're doing is we're asking you to let us know what the problem is. If you happen to get a constituent who is interested in our services or our help, the issue, you got to select one and then provide us with some information about the business, and then actually your information. And that way we can follow up and let you know how we resolve the situation. Okay, so this is an online tool that will actually help make it easier for your constituents' problem to get sent to the team immediately. So based on the what you're selecting in terms of whether or not it can be navigating government, and the issue is demolition support, and you explain the situation to us, we're then able to send this. It gets transferred to the team immediately. It's put in their queue for follow-up. And like I said, we are collecting your information as well so that we can let you know the resolution of the situation. So we're really proud to be able to share this with you guys, and you're going to see an email from us. But I would also say, if you're interested, we would really love to be able to come out and make presentations to your community. We'll work with you to walk the corridor so that you can see what our compliance consultations are all about, or host a legal clinic. We're here to help all the small businesses and any entrepreneur who's interested in starting a business. Okay, so we're here. It's a full suite of services. If you would like to have a conversation one-on-one or arrange something, I'm going to put my email, if you don't mind, I'm going to put my email address in the chat. And please feel free to reach out to me. I really, again, would like to thank you all for giving me this time. And I didn't know if I could take a question. If anyone's got a question, I'm more than happy to answer it. If not, please feel free to email me. Thank you. 3 minutes, Susan.
Very good. Thank you. Any
Thank
questions before we go? Okay, now Jeffrey Garcia.
Robin, I think Robin's got a question.
Hi, Robin has a question. Quick question. Is this partner referral, is this restricted to use by government entities or business entities?
Oh, no, it's what it is so we still have the form online where a business owner or an entrepreneur can reach out to us directly, but this is specifically for you so that we're able to follow up. What we found is sometimes someone will come to us and they'll say, oh, there's this business, but they don't have I don't remember who referred me and blah, blah, blah. And then sometimes later we'll hear back from someone saying, did you hear from this business? So we want to be able to help you.
Great. No, perfect.
And one of the other things is sometimes you're working with someone here at SBS, but they may not be the appropriate team that this problem needs to go to. By using this form, it will go immediately to the queue of the team that needs to work on it.
Okay, one more question, Mina, and then we'll go to the MEND program.
Hi, Nina White, with Community Work 10. Just really quick, would you mind putting the link in the chat?
We are actually going to receive an email shortly about it because we haven't released it yet. It's actually, my tech team said, are you going to show it? I said, yeah, it's actually technically going live on Thursday. They're still doing UAT testing on it. And I said, no, I got to show it off. So you're the first ones to see it.
Okay, thank you. I think it's great that we'll get feedback on what's happening. Really appreciate that. Now we'll go to the MEND program and our director of Nightlife, Jeff Garcia.
Yes. Am I off mute here? Hi, everyone. Susan, thank you so much. Kitty, thank you so much for that presentation as well. And thank you, Commissioner Kim. Good afternoon. Obviously, Susan, Celeste, thank you for organizing this today. We have spoken many times and met. So obviously, I'm happy that we got this meeting on the books and, we're able to present to to the rest of the community boards. I would also like to extend my thanks to Judge Kramer and Holly. Thank you for the work that you're doing at Oath and putting this together and presenting and administering the MEND program. You will be hearing from them in a minute. Today, they'll be sharing some details about the additional tool we have created with them to help reduce complaints and improve conditions. For community board leaders, we know you deal with a lot of quality of life issues and often help residents and businesses navigate that. We understand that the nightlife establishments can offer a unique set of challenges when balancing the needs of local residents. And we hope that this program can help take some of those challenges off your plate. Through MEND, we're ready and able to assist with free mediation via Oath's Center for Creative Conflict Resolution. This program is an additional tool to help reduce complaints by bringing the parties together and communicate directly. We are pleased that other agencies like NYPD, DEP are helping promote it further. Mediation isn't a silver bullet, but it's another tool I would use, right, from my law enforcement background in the tool belt. So to help improve neighborhood relations where nightlife establishments are involved. We know that in many cases, listening to one another, we can make all the difference in finding common ground. Mediation can be challenging, particularly in a city like ours. And like the commissioner said, there's 8.5 million people, or like the mayor says, and 10, 20 million opinions. But MEND has been working. When both parties proceed to mediation, MEND is more than 85% successful with its resolutions. This program is here to assist you and your constituents in navigating difficult conversations and quality of life concerns. We're here to share a bit more on how it works and look forward to your questions and further discussions and encourage your referrals. Now, I'd like to turn it over to Judge Kramer and Holly for their presentation. Thank you so much. And I just want to give a quick snip. Last week, we went and visited businesses in Queens, and we're doing that all over the city. And, we're speaking to our business owners out there about quality of life issues. So we're also making that connection with them and letting them know that we're here to help. So know that you guys can always reach out to us as well if there are issues going on with businesses in your neighborhoods. Thank you.
Yeah, thank you, Jeff. Appreciate it. Can everybody hear me okay?
Yes.
Good. Yeah, happy Monday, everybody. It's nice to be with you. I'll echo some of the thanks to the SBS team. Thanks to Jeff, Jose, Kitty. Great to see you again. It was great to hear that Commissioner Kim is a mediator. That was really terrific. Thanks to the commissioner. And Susan, thank you. And all of you from the community boards for inviting us to participate today and to talk a little bit about the MEND program, which we're excited about and happy to administer. My name is Ray Kramer, and I serve as the executive director of the Center for Creative Conflict Resolution, which is a center I'll talk about a little bit more in a minute, within the larger umbrella agency of the Office of Administrative Trials and Hearings, Oath. Hallie put our pictures up. I kept the same hairstyle. I haven't changed it. I have been a long-serving administrative law judge for Oath, and in that role, I have been able to resolve conflicts in the most formal way, through litigation or settlement conferences conducted in the shadow of litigation. And there's a place for litigation for some conflicts, but lots of conflicts get funneled to litigation, not just in the administrative law context, but in the community in general, because there aren't other options. And I've long been trained as a mediator, interested in other forms of conflict resolution. So I stepped out of the courtroom a few years ago to help launch and lead our Center for Creative Conflict Resolution. The idea there is to, as Jeff said, just to expand the toolbox, to not eliminate options, but to expand options for conflict resolution. I'm here with my colleague and dear friend, Hallie Annaly, who's our Director of Education and Training. Hallie, do you want to say hi for a minute?
Hi, thanks for having me. You'll hear from me. You'll hear from me a lot later.
All right. I didn't mean to put you on the spot, but I wanted to get your voice in here. Yeah, so that's a little bit about us, and we're here to talk about the MEND program. We were thinking we'd share some slides and talk about the program and some of the mechanics of how it operates and some of its benefits, and then open it up for Q&A. So you all have a chance to ask whatever questions you might have on your mind regarding the MEND program. What is MEND? It's an acronym for Mediating Establishment and Neighborhood Disputes. It's a citywide program. It was created in collaboration with the Office of Nightlife and is now held by the mediation program is administered by our center. And the idea was to provide an option for community residents and businesses who may be experiencing conflict over quality of life issues. So we offer free mediation or other appropriate conflict resolution services for community residents, for businesses in the nightlife industry, which includes, as you know, bars, clubs, restaurants, live music venues, or special event centers. A little bit about our Center for Creative Conflict Resolution, which is the entity within OATH that holds and administers the MEND program. The center was launched as an initiative in 2016 to provide conflict resolution services, including services like mediation, conflict coaching, group facilitation, conflict resolution, skills training, to provide that conflict resolution services for the city's workforce. And that had been our focus. And by February of 2021, Mayor de Blasio issued Executive Order 63, seeing value in the conflict resolution services that we offered. And also we had launched MEND during the pandemic and seeing value in the MEND program specifically and the opportunity to find ways to implement ADR, alternative dispute resolution processes like mediation in city government public facing work. Mayor de Blasio issued really an historic Executive Order 63, which named the center as the city government's central resource for conflict resolution services and restorative approaches. And the executive order expanded our mission in that our original focus had been on the workplace and supporting conflict needs for city employees in the workplace, started to look at how we can support agencies in using ADR processes like mediation in their public facing work. And now both are a vital part of our mission. And MEND is one of those public facing programs in which we are offering a conflict resolution service as an option, early intervention option to the enforcement process or to litigation. I think here I'm going to turn it over to you, Hallie, to talk a little bit more about the specifics of the program.
Yeah, thank you, Ray. And can everyone hear me? I was told I was a little far away before. Yeah, thanks, Susan. Okay, so there might be, like varying levels of familiarity with MEND for people on the call. So like Ray said, we have a few slides that will provide an overview. It might be new information to some and old information to others, but I'm kind of just going to go over it broad strokes and then leave time for questions. But, Ray said this already, but who should use MEND? It's really an option for residents that are making quality of life complaints against a business that's receiving quality of life complaints and wants to be proactive and schedule a mediation with a neighbor. Like Ray said, it was started during the pandemic. So we also included if a business was having trouble with their landlord, that could be something for mediation. That hasn't been used very often, but that it was part of MEND's mission. And really I think the core takeaway is that both parties have to be willing to participate. It is a voluntary process. So that's something that from the very beginning, when we receive inquiries about either from neighbors or from businesses, we're asking if this is something that they'd like to do. And if the parties are already engaged in either a formal litigation process, a regulatory process, then those cases aren't appropriate for MEND. It makes sense to let that process play out. And then if there's something to do after it, maybe mediation can be appropriate, but it's not appropriate when parties are already involved in another more formal process. And what is mediation? It's one of these words, I think, that is used a lot and we hear it a lot just in our work of when people call something mediation and it's not mediation. So this is a very quick overview of what mediation is. You know, it really is at its core a facilitated conversation that is facilitated by an impartial third-party professional that really doesn't have connections or really authority between the two parties. And the next slide we'll talk about who the mediators are, but that's really like it's someone that's outside of any authority or relationship between the parties, and that it's a voluntary process, it's a private process. It's one where the participants, you might hear me say this, sometimes I say parties and sometimes I say participants, but it's really the participants that control any outcome that is come to or is reached in mediation. The mediator is not the decision maker. They're really there to guide a conversation, and our training is really in how to have productive conversations. So that's what we're there to do. And mediation, just generally this form of mediation where parties are decision makers rather than a third party being the decision maker, is really premised on the theory that the people that are most directly impacted by the conflict are the ones that know best how to resolve it. And if the two primary people in dispute are in charge of creating their own outcome, then it's just more likely that it'll be followed through, that it'll be more likely that there's lasting solutions. The mediators, so Ray and I are, I don't know, 1/3, 1/4 of the center staff. We're a small team. We have 7 service providers and 2 administrative support. So especially when the MEND program first started, we all mediated a case or 2 in-house to make sure we understood the contours of the process. But we really work with a network of mediation providers. One of them was already mentioned by Commissioner Kim, the Brooklyn Mediation Center, that now goes by the New York Peace Institute. So we're connected with all the community dispute resolution centers. New York Peace Institute serves Brooklyn and Manhattan. The New York Center for Interpersonal Development serves Staten Island. The Institute for Mediation and Conflict Resolution serves the Bronx, and Community Mediation Services serves Queens. And so when cases come to us for mediation, we'll either mediate them in-house, we'll send them and work with Community Dispute Resolution Center, or we also partner with law schools in the New York area. Almost every law school has a mediation clinic where students are trained and also under the supervision of attorney mediators that oftentimes are trained at these community dispute resolution centers or other places to mediate exactly these types of disputes. So these are some of the law schools that participate and receive referrals as well. And all mediators complete required initial and advanced mediation training to hold themselves out as a mediator to mediate these disputes. So appropriateness, we think about it in 3 buckets. Again, this first bucket is really far and away the most referrals we receive are really quality of life issues between residents and businesses. But like I said, like MEND was set up to see if, wanting to think creatively, if it could be helpful between businesses and landlords, or we have received a few referrals between neighboring businesses that might have quality of life disputes kind of against one another. Like there was one that I received, I don't think it went to mediation, but it was where like one business was feeding the pigeons that were coming to their backyard, and that was resulting in the business next door receiving more pigeon waste than they wanted to. So there was an idea of like, would that be appropriate for MEND? And we said, it's a dispute between two neighboring businesses. Like we could at least have an intake and see if they're both willing. I don't think they were willing, but it was like a example of a misunderstanding between businesses. I remember doing one during the pandemic where there was a shed that was, they shared a driveway, two businesses. And when outdoor sheds was being built, they wanted to have a discussion of making sure that they could each use the driveway appropriately in the way that they wanted to, and didn't want the shed to impede on that. But again, those are kind of outliers. The most are between residents and businesses. And what we're kind of looking for as cases that are really appropriate for MEND could be best served by the program is when there's specific issues, like the they must have moved the speaker because everything was fine, but now I can hear music and it's underneath my child's bedroom, or like it was, they must have been started to open the windows because now the noise is traveling outside in a way that it didn't before. Or, there's a different smell that's coming that when they take out their trash in the courtyard that shares where I have a window and it never used to smell like that. And now it smells different. I'm just giving you things that I know you have all heard before, but like, we're really like trying to hone in on specific issues, not wide ranging complaints about how a business operates, and where, it might not rise to the level of enforcement, like maybe it's still within the decibel level, but it doesn't mean that it's not, impacting somebody's quality of life, and that a conversation couldn't be helpful to find out like really what is happening, and are there any creative options, solutions where through direct conversation things could be improved. And again, this last part, really like appropriateness too, is if both parties are willing to have the conversation, because if they're not, then MEND's not appropriate for that type of conflict. The benefits, we all probably experience this just in our own lives. Like when you get two principal parties in the room together, things can get resolved faster. It can save time. Like I had said before, it does give parties a direct voice in the outcome of their conflict. You can go to a mediation and not come to a resolution, and that's okay. Like, hopefully you've at least each of you have learned more information about what the neighbor's complaint is, and also what the business is doing, has done to try and resolve the complaint. But the thought is like, when that direct conversation can be had, there's just possibilities that parties will want to be involved in solving their conflict. It also establishes direct communication between the two parties. Like we've found a lot, and I'm sure you've experienced this too, because of because of a past relationship that wasn't good, or like the power dynamic between a business and a neighbor. People aren't always keen on just having conversation directly between the two of them. So we've found sometimes just giving people the space that is held by a mediator, but is really allowing two people to have a direct conversation with each other. It can be the first time, or it can be the first constructive time that parties are really able to have a direct conversation about the conflict. And it also leads to sometimes like agreements can include people exchanging direct contact information with each other. You know, a lot of frustration can come from a neighbor not knowing who to contact or a business owner not being there. So then they get routed to a manager, but a manager changes every night. So sometimes agreements include, or information includes, like giving direct contact information to prevent future disagreements from coming up. You know, they can, in having this conversation, they can learn exactly, the business can learn exactly what the neighbor's complaint is, rather than just, you know, it's noise. It's like, well, when is it, and where is it, and where do you live, and where, how, like, is there a time when it's impacting you? Was there a change when it was okay and now it's not okay? Like, to really get more information when sometimes through either enforcement or 311 and businesses receive complaints, they're not complaints that are actionable, where they know what to do to try and resolve the conflict. You know, save city resources by reducing the need for enforcement. It develops, I think the ones that I find at least most satisfying are the ones where it develops ongoing relationships between parties, where they now have, you know, a little bit more contact, really, and understanding to be able to work things out in the future among the two of them. And then who should refer cases? This might be obvious, but we do get we get referrals from all four of these buckets. I would say maybe the most high volume is from neighbors that find our information through Googling or through 311, but we do receive referrals from neighbors, from businesses, from city agencies. Like, I think Jeff mentioned this, like NYPD or DEP. We do receive referrals from community boards, from elected officials, from bids, you know, where they've either, you know, done their own form of like mediation, their own form of trying to resolve it between the two of them, and maybe not only as far as they could get and would like some more support. So, you know, we've received referrals from all of those places too. And then, you know, why, when to refer cases. Again, when parties are willing, that's honestly like the best, the best, you know, gauge, but really thinking about it as an early intervention option. So parties can, you know, have a conversation with each other before it escalates, because oftentimes things do come to us after things have escalated, after people have had negative interactions with each other, which all of us probably know. It's much harder to work on a creative, collaborative solution when people have had a history of negative interactions with each other. So early is always helpful. With those that are interested in direct communication, you know, even maybe prior to engaging with enforcement agencies. And then, you know, just to be really clear, you know, the quality of life, these issues are resolved through the MEND process. And sometimes if they are, it could be faster than going through an inspection process or waiting for a summons to be issued. But the MEND process is separate and does not involve oath summonses. Like, that's a separate process that goes through the hearings division. If that's the way parties are have gone, or, you know, would like to go, then it goes through a summons process, and MEND's not involved. I think maybe there's one or two slides more. Yeah, how to request a MEND mediation. you can, and I can put both of these links in the chat maybe after the presentation if that's helpful, but we get a lot of inquiries from our online mailbox, from our email address, or we have an online form that neighbors or businesses could fill out to request a mediation. And once we receive that form, then someone from MEND will do an intake to really assess for appropriateness. Like, does it involve a neighbor and a business? If whoever reaches out first, are they interested and willing to have a direct conversation? And if they are, then it's only if they say yes that we reach out to the other party and offer the option to them. And if both parties say yes, like, I'd like to give it a try, I'm willing to see where this goes, then that's when we connect those two parties with one of those mediation providers, either us or CDRCs or law school clinics, to actually provide the mediation service. And then we do send out a survey. Again, probably like all of us, we don't get as many responses as we want because there's survey fatigue, especially online survey fatigue. But we do send one out after every mediation, and there's some pretty very cool testimonials that people have given about the program. And I realized I just said that the survey is online, and I would say 99% of the mediations are also held virtually too. I don't think I mentioned that. And it was, like Ray said, it was a pandemic program genesis. So virtual was the only option really at the time, but we've also found that in most cases works for people that are doing this voluntarily, that are often working, that don't have the time or the interest in really taking too much time out of their day to have this conversation. So we host all the mediations online for the most part. And I think that's all. We have 18 minutes, which was what I was going for, between 15 and 20. So I feel pretty good that I'm in that time frame. I also, that I said a lot, and Ray, I told you I would pause for you, and I didn't. So if there's anything that you wanted to add.
No worries. Thank you, Hallie. Yeah, I just wanted to highlight a couple of things. Hallie said this, but mediation is voluntary. It's voluntary to participate. And then once in the room, it's voluntary with respect to whether parties reach an agreement and on what terms. As mediators, all of our mediators, the ones that are part of our network or certainly our team, we're facilitative only. We're not making judgments or evaluating or telling people what we think should happen. We are really facilitating a conversation. And I emphasize that because you're not waiving your legal rights if you participate in a mediation. So a community resident, a business can try mediation, see if there's a way to resolve together. And if not, the enforcement process remains. So it's not, the MEND program was never meant to reduce enforcement or take away or preclude enforcement. It was meant to provide another option. Another way to think of it, I spent years, as I mentioned, in the litigation process, resolving cases in that most formal way. And I think we all know, how time intensive, resource intensive, and how often unsatisfactory the litigation process is. With respect to the enforcement process, the idea, I think, is to gain compliance through punishment, through enforcement, punishment being in the form of a fine. And that's appropriate in some instances. But if you think about the dynamic, it's a win-lose dynamic. One or the other side wins if it gets to a summons and a hearing. And the focus is on the transactional, whether the sound level, for example, exceeded permissible levels. With mediation, and Hallie mentioned this as well, it's not a win-lose proposition. It's meant to be a win-win. What does each party need? What does the business need? what does the community resident need, and how can they fashion a resolution between themselves where both needs are met. So it's really a problem-solving approach, rather than a transactional approach. And in mediation, which I don't think exists in the enforcement process, there's room for creating a healthy relationship. And Hallie did mention one of the things that comes out of these mediations is just the beginning of a relationship where parties haven't talked directly to one another. My own experience in mediating some of these cases, and I think Hallie would confirm this, is that the community residents generally don't want to shut down businesses. They recognize businesses have value to the community. I've had mediations where the neighbor is saying, I'm a patron in your business. I like your business. This is not about your business and its right to exist. It's about my ability late at night to get some peace and quiet, or for my child to be able to sleep undisturbed. And the business recognizing, it's important to their business to be a good neighbor. So when they're in the room, there's generally, in my experience, an interest in creating or maintaining a healthy relationship. So there's room in mediation to tend to the relationship as well as to address the transactional issue. In the enforcement process, that's not generally the case. And again, that's not to say there aren't instances where people may only respond to the enforcement process that way. That's why it exists. But I just wanted to highlight the fact that one could try mediation. If it doesn't work, that enforcement process is still available. And I think with that, thank you, Hallie. If we could open it up to questions.
And Ray, if I could just make one point before we start the questions. None of these mediations change any legality, stipulations, permitting that a business may have, right? The mediation, like you said, is just so that the two groups can come together and talk and fix what the solution is that is causing the problem, right? I just want to make that clear, right?
Yeah, thank you, Jeff. That's right. We're not mediating conditions for a license or any of the regulations that may apply. Really trying between neighbor and business for them to problem solve, to come up with a resolution so that both sides can be peaceful and good neighbors with one another. But thank you for clarifying that, Jeff.
Right.
Okay.
Yeah, Mark? Oh, I'm sorry, Susan. Go ahead.
No, go ahead. I was just going to call you also.
So thanks very much for the presentation and the description. We had a brief of something scratching here. Sorry, maybe that's better. The perils of having a beard and a microphone thing. Jeff might know a little bit about that. There was a brief presentation before, but this is obviously much more complete and much more helpful. I'm still processing the whole voluntary part of it and whether the worst actors in the West Village, which is my domain, would ever either agree to it or agree to do what it is they said once they're in that meeting. But there's a process point that I'm actually want to start with, which is there a privilege that attaches to what's said in the mediation? I'm thinking that if mediation fails and you end up in any kind of enforcement proceeding, whether it be litigation or oath or whatever it might be, it could be a way, it could be free discovery, and you'd end up with folks getting access to information that they wouldn't otherwise have, and that could be an impediment to the willingness of either party to participate in the process. The idea that they're giving away information for free that would then be used against them. Can you speak to that? Is that a real issue, or is just my lawyer's brain working overtime?
Well, I would say it is a real issue, but it is also a common perspective for lawyers wondering whether mediation makes sense or if there's a disadvantage for the client. So a couple of things. There's something called the Uniform Mediation Act that many states have adopted that actually makes what's said in mediation a privilege, but New York State has not adopted it. So in our program, we have the parties sign an agreement to mediate form in which they acknowledge they're mediating voluntarily and they acknowledge the confidentiality of the process, with very narrow exceptions that have to do with imminent harm to self or others, or engaging in some form of serious criminal or corrupt act, but otherwise it's confidential. So if there were an issue around the confidentiality that came up later in litigation, it would be up to the court, but the argument would be the parties signed a contract binding themselves to keep the content of the mediation confidential. As mediators, we have ethical obligations. We'd have to respond to a subpoena, but we have ethical obligations to keep the matters confidential. We keep no notes. We keep minimal records to protect confidentiality. Yeah, there was something else I was going to say. Oh, with regard to discovery, my experience, your experience may be different. I know in administrative hearings that come before oath, open and full discovery before trial is the norm. So whatever parties have is going to have to be shared generally anyway. I think that's becoming more and more true in the criminal context and in the civil context, that there's no trial by surprise. So if one is learning things in mediation, I would say it's probably something that if you're going to go through a litigation process, you're going to learn anyway. But honestly, in the mediation, Ali, you can speak to this too, mediations I've been involved in, it's really been basic about, look, I don't want to shut down your business, but I'm having trouble sleeping at night, or people are hanging out outside, and can you do something about it? And it's been more problem solving. And, let's share phone numbers. And if you have an issue, call me. I'll talk to the manager. We'll adjust the sound, or we'll do X or Y. And then the last thing I'll say, which you probably know, Mark, is, whatever's known outside of mediation is known. So the fact that you talk about it in mediation doesn't subtly insulate it. So if things are known, talked about in mediation, but they were known anyway, that's not confidential. So I hope that was a complete enough answer for you. But ultimately in litigation, it come down to the contract the parties sign.
Got it. Thank you.
Raphael?
Hi, yeah. I just wanted to ask if MEND has done any mediations between community boards and any business owners. I know that my board has concerns about potentially recommending revocation of liquor licenses, and I'm wondering if, obviously we have our own hearings and our own committee meetings where we invite business owners to come, but I'm wondering if you've ever tried mediation between a board and business owner to provide some of this extra service beyond what we already do. Thanks.
I don't think we have.
It's an interesting idea, but yeah, I don't think we have either.
It would probably be the same premise, like if there's willingness, Raphael, like on both, like that's really like the first question would be like, are parties willing to, like are parties willing to participate, and also, or maybe in conjunction with like really making clear what the process is and what it isn't. That, like, it is a facilitated conversation, but any agreements, any outcomes are really up to the two parties, and seeing if that is what would make sense for, the conflict.
If I could help answer that, Susan,
Sure.
I would like to inject that, please reach out to our office if you're having issues like that. Obviously, we have other programs that we've instituted to replace, let's say, the March operations, right? Which is CURE, and it's coordinating those relationships and with those establishments. So reach out to us. We can be more than helpful. I want to be helpful. Our office wants to be helpful. And hopefully getting businesses to comply with whatever issues you're having as well. So it's not necessarily a MEND, but we definitely, like I said, we've been out talking to businesses. We've done proactive outreach to businesses that are problematic. I was just out in Queens last week, talking to businesses that we got reports from the NYPD about. So we're more than willing to assist you in helping out with these businesses.
Got it. Thank you.
Okay, if I could ask a question, I didn't see any other hands up. First of all, as the rate of success, I would like to suggest that, and maybe you do this, but I don't think so, that you check like 6 months later, because I have had an experience, and I'm sure this has happened other times, where people leave a mediation thinking everything's wonderful, and 6 months later, nothing's changed. So I wonder if there's any tracking at a later point. And then I'll just ask my one other question. I've brought this up before, and I've talked to Jeff about this. And I've, when we had the first presentation over a year ago, and that's stipulations. And these MEND are dealing with issues that are often already covered in stipulations, but nobody in the session knows that. And the stipulations are legal. They're part of the method of operation. And for instance, one of ours is often music cannot be audible in neighboring apartments, which is beyond the law. But it's what the stipulations are. And I was hoping that there would be a way that that MEND could at least ask what the stipulations are and acknowledge them, or get a copy of them for the mediation, so that all that work that has been put into it to try and avoid problems and to try and have businesses and neighbors coexist would be supported. Thank you. Any answer to that?
Yeah, I can. Well, two things. I think the 6 months follow-up, it's a great idea. We also have that same idea for our workplace mediations. And it comes to like a question of resources, like to like if you find out that something isn't going well, like, do we all have the resources to keep going? Do we all want to? Like, what we usually say in our agreements, and sometimes realistically, like, people don't take it up, is like in the template of the agreement is parties, if this mediation, if the agreement breaks down, like, parties are willing and are invited to reach out to the center to participate in a second mediation session. It's just oftentimes this might be just reality. If one process didn't work, they might not be so willing to engage with that same process again, and they might want to engage in something else. But it's a topic that just as a mediation process, like we talk about a lot, like, so it's a good question. And with the stipulations, I could maybe say a little, and if Ray, you want to add, what we usually ask all parties in mediation is like, what would be helpful to know that you don't know? Like, it's like a question of that, like what information do you not have that would be helpful for you to have? And we would encourage people to get the information that they need, and maybe, like, to what you're pointing to, that there could be a more pointed question in there, but we want people to be making informed decisions, that will help them resolve whatever the underlying issue is, and trying to get them connected to resources that would give them that information, rather than us from this regulatory or from this more authority place saying, here's what you need to consider, or here's what you need to comply with. It's really trying to broaden it to ask the parties, what information do you need, and how do we get you the resources to get you that information, whether it's connecting with your community board, connecting with DEP, connecting with, sometimes the PD is appropriate, things like that. Ray, do you want to add anything? Oh,
yeah. Well, yeah, I think that's correct. I think for us, for the program to work effectively, it's important that we be and also be perceived to be impartial, not aligned with Oath, the tribunal, and that's why the center exists, although it's within Oath. It's separate and apart from the tribunal, not aligned with SBS or ONL, but neutral. So for us to interject, information, that might support one side or another, or be perceived to support one side or another, or sound like we're making judgments, impacts on our effectiveness as neutral facilitative mediators, if that makes sense. I think Ali addressed it, but for the community residents to know that there are those stipulations and conditions, and that they might have another avenue other than mediation, I think is important. And I'm wondering if that can come through the community board itself. And certainly we can ask the questions, like Ali said, we are asking, is there anything else you want to know? Any other information you want to gather before you come into the room? But in the end, we're not making judgments around are you complying or not. We're having the parties focus on, what do we think as the parties we can work out and live with. So I hope that helps, Susan. I do like the idea.
I don't think most residents know that stipulations exist. Many of them don't know a community board exists. And even, I'm going to say business owners. So when the community board is involved, one of the things we do is say, do you know you have these stipulations? Because they often don't understand what it is they've even signed. So that's why I actually liked it when the police were involved, but in an always started in an educational way, and said these are your stipulations. I always found that was helpful. And I've given stipulations to business owners that didn't even remember that they had signed them. So
I was just wondering, without MEND, how did it work in terms of community board residents calling 311 and then being steered to DEP or calling NYPD? Would they learn in that context?
No, never, because stipulations are strictly on the state license. The only way they get involved in the city is I give them to the police, and they will visit the bar or the restaurant and say, these are your stipulations. It's always for many years been an education first process. And then if they continually refuse, then the police will send an incident report to the SLA and say, I observe this.
Got it. Yeah.
Okay, I don't want to hog up all the time. Can we go to Zach?
Hi, thanks so much. I was just curious on the average timeline from when you receive an inquiry to when the parties get contacted, when they agreed to come together, and when the mediation happens and ends. What's sort of your average timeline that you would want us to expect, or would be helpful for us to expect as we would refer a case to you?
That's a good question. I think if you're sharing the message to just ask for patience, is probably something that's helpful to ask people for, because sometimes it can just take as long as businesses are willing to contact us. Or if the neighbor's the first person that reached out, usually we ask the neighbor, we try and have a conversation with the neighbor first to make sure it's appropriate for mediation, that they actually want to have a direct conversation with the business. So sometimes sometimes neighbors get back to us right away. Sometimes it takes some time. And then Once we receive that, then we reach out to the business. We usually try and reach out to the business 3 times so cases don't kind of linger for too long in this intake phase. I know that our intake team likes to close things as quickly as possible. So, like, if a business doesn't get back in a week or two, then, you know, they'll let the neighbor know that we can't reach the business, so we can't move forward in mediation. But if the business does respond, we do have that conversation with them and it gets sent to mediation. We usually say that it takes around, that they'll at least hear from a mediator within 10 days to set up a mediation. So we try, like, once we get the yeses from both, it can be much faster, because then it's really just a question of people scheduling. But sometimes getting that yes from both parties can take a little bit of time. So the time that I would suggest maybe giving is saying once both parties agree to the process, you'll usually hear from a mediator within 10 days to schedule the mediation, because that's what we tell them via email.
Thanks. Quick follow-up on that. Would it be helpful if community boards were able to connect with the business and get them to agree to mediation in advance to sort of jump that hurdle that you have?
Yeah, like sometimes we do receive like from either community boards or electeds or NYPD's neighborhood community officers, like they'll, or ONL even, like will send us send MEND an email that says, I talked to the neighbor and I talked to the business, and they both have said preliminarily that they agree to mediation, and here's the contact information for both sides. So then, like, Zach, what you're pointing to, like that initial yeses have kind of already been at least preliminarily received. So we'll still do outreach and make sure and confirm, but it's always helpful when parties hear from people they trust, honestly, before they hear from people, or at least they've had some relationship with, before they hear from an entity that they've never heard of before, most of the time.
Thanks.
Yeah.
Okay, Anthony?
Thank you, Susan, and thank you to my colleagues for all being here. Very quick questions. I'm wanting to learn more about, also like Ralph from CB6, if you can talk to our board about your work. Has are community boards made aware when mediation happens in their district, whether or not they institute or they initiate, excuse me, the mediation? Or like, do we find out, hear the results of the mediation, or this mediation has happened or is planned to happen in your district? Then I have some follow-up questions.
Yeah, I don't think we don't proactively share this mediation happened in your district or something like that. I think it has happened, especially like with that example, that like hypothetical example that Zach was given before, where like a community board or like an elected official has made a lot of contact with the parties beforehand and gotten that preliminarily, like, yes, we'd like to agree to mediation. And we've maybe even had a phone call with that person from an elected's office to get in because they've been holding a lot that like will let them know, like if the parties came to mediation and what the outcome was. But it's usually when there's somebody that's been involved in some form or fashion beforehand.
I asked this only, and hopefully I didn't cut you off, because as we make SLA decisions, it'd be helpful to know when things like this happen in our district, so that we can be able to learn more about whether there were, because we likely may not hear about all the complaints first, or in terms of making those decisions. So it would be good to know that something historically has happened. And I asked this to Susan, and she said no, whether or not any of the stipulations from the mediation are usually enforceable, if not by the nightlife. Could it be used as an oath, meaning that this is something that's been happening repeatedly, that's been going on, and with this particular business, and apparently there has been going, bad acts, or not being a good neighbor. And so this is something that's going on. And I know that nightlife likes not to be punitive, but we understand that sometimes not all of our establishments often don't work out to become good neighbors, and they are, they have a successful business of some sort. But so I'd just like to know more about how are we working as a city to ensure when there have been repeated offenses, usually around the same issue, that mediation, oath, whatever it is, that these actors are not, looking to be good neighbors, because since we remove the the immediate punitive interactions. So I guess it's a twofold question. Can CCR engage or inform community boards this has happened, so that we make our SLA decisions? And then secondly, are we working to put, as we look at to either nightlife or whether or not these mediations, as they pile up, if they don't pile up, are looked at, and making decisions of whether or not these business owners are being good neighbors? Thank you.
Well, if I could just speak real quickly, if let's say mediation doesn't work and complaints continue to come in, obviously, at some point we would be notified. NYPD would be communicating with us, or any of the other agencies. So we can also help with that corrective action and letting them know what will happen eventually if these conditions are not mediated or fixed. And again, it doesn't necessarily mean that it goes to mediation, but that if they don't rectify them, then enforcement can still happen, at some point. So it doesn't mean that there is no enforcement, and it won't happen if these folks continue to not adhere to whether it's a stipulation, or they keep creating a condition that is not legal. Then that condition eventually will be enforced by the specific authorities.
If I could speak to Anthony's point, that same business might be coming to the community board to have their hours extended or their license upgraded. And if we don't know that there's a problem, and nothing you mentioned will let us know, that even though the state charter says that the SLA must confer with us, we won't have the information because everybody else is dealing with it but us.
Well, I can tell you this.
And I want to add to what Susan is saying, if I may, Mr. Garcia, is that this is why community boards are extremely important, and this is why clearly we need to have a clear understanding of what's the time frame of things happening. Like this means that this is going to happen at this time, this continues in this, if it's something that we could put in writing versus verbal, and I'll stop right there. But I think it will help us to have teeth into this process, and teeth about, okay, this is when nightlife jumps in, this is where other options should take. So I just ask that everyone make those considerations about how we're the frontline organization that hears these complaints first before they may go to anywhere else. And I'll stop right there. Sorry to interrupt you.
No. Thank you. Listen, I've been involved in this nightlife scene and world from an advocacy perspective, and then now, in this role, and prior in law enforcement. And now more than ever, I find it highly unlikely to find places that just go completely under the radar nowadays, with the facility of 311 and people being able to make 311 complaints. We seem to have a pulse on what's going on. Again, whether it's through NYPD or through community boards or other means like social media. So, we get complaints coming in through all those means right now. So we definitely address them right away. And again, if some of these can be handled through MEND, we will recommend as well. But you know, I don't know of any places that just go completely under the radar like that, and no 311, no, the community board doesn't know about it, NYPD doesn't know about it. Especially if it's a legal business, right? Which are, we don't have any authority over any illegal businesses, and illegal businesses cannot go and do MEND.
I was just going to add.
So I don't know. Right. I don't know. Right. Thank you. I don't know whether or not if CCCR wants to comment about sharing the mediation. And I'm sorry, Susan. I know you're gonna shake your finger at me soon, but it's gonna, but sharing the whether or not there are mediations happening or history of mediations that happen with businesses in the district. I think that'd be very helpful when we're making our SLA recommendations.
Yeah, no, I appreciate the concern and the questions, Anthony. I was going to speak to the oath hearings part of it, the enforcement part. And the CCCR is separate from the tribunal. And we don't want to create a mediation process where any agreement that's reached, and usually the agreements, in my experience, are really general good faith agreements to try and work together with one another. So we're not looking to create a process where if it breaks down, that in itself is actionable. I don't think we have any authority to create a sort of a new cause of action because parties voluntarily tried to work it out in mediation and it wasn't successful. If it's not successful or if it breaks down after an agreement, however general or specific, then the parties are free to pursue any avenue that was already available to them. So we do not report, nor would Oath consider as a way of either finding against a business that has a summons pending or enhancing the penalty, the fact that they may have previously participated in mediation and those mediations may or may not have ultimately been durable. And I guess I'm just listening and thinking, for the program to work, we're really doing two things. We're trying to engage people voluntarily in the process. And we are working on trying to shift the relationship so that when there is an agreement, it's just not superficial. It's not, we're, as mediators, part of the skill set is to not let people yes us without really making sure there's a good faith commitment to follow through. And if we don't get that in the room, then there's no agreement. It goes as a mediation where there is no resolution. But I don't think we want to be in a position of reporting things out, reporting what has been successful and what hasn't, because that may impact both the willingness for people to participate and the appearance of impartiality. That would be my concern, but I get the question and the interest and appreciate that.
And I guess I'll just add one thing too. It hasn't been like in practice our experience, nor would it be like for the reputation of the program too, for it to be and maybe like Mark was kind of alluding to this too, like for it to be something that people participate in to like try and get away with doing something else or without doing something else. And kind of to that same point, it's not really the appropriate process for like I think you said, Anthony, for like repeat offenders, like if a business is coming back to mediation multiple times, like first, I actually don't think it just in practice has happened, probably because if it didn't work out once, then they just say no the next time or like, but it's not meant to be like a workaround. And that's why we do the intake and we do the case development to actually make sure that people are participating for the reasons that Ray was kind of mentioning. so it can be a credible process in itself.
And the same goes for our office. We don't get the results. We don't get involved in the mediation process. Again, that is handled completely by Ray and Holly's team and the mediators. Once we refer, we are out of that space. And the idea is, I'm sorry, Holly. And the idea is obviously that once mediation happens and, you know, all parties are happy, then that means hopefully the issue isn't happening, right? The condition is no longer happening. So that means we probably won't see it through one complaint based on that condition. And if the condition is fine, it means that I could almost assume no stipulation was violated either. If there's no complaints about a business, that means they're not really violating any conditions.
I'm going to say something. I just said it to Susan. I'm going to say that something that all our bosses says: inspect what you expect or suspect. And I'm saying that this is likely, you know, another time where the press, if anything happens in a situation where we had businesses go through this whole process of, you know, checking on the boxes against SLA license, checking on, you know, dealing with the mediation and so on, and this something comes out of control. Like, for example, I have an issue where there was a murder allegedly connected to an establishment in my district. And when the systems don't speak to each other, and we have this unfortunately happen so much in our city where systems don't speak to each other because we don't, you know, for whatever the reasons are, because we want to give this ability, this system a try, or whatever this project a try. I think that it unfortunately takes away what can enhance it by just saying, hey, community board, this is something that we're doing, and so that you know, because if the press gets a hold of an establishment where obviously they're not good neighbors for whatever the reasons may be, the first thing that was going to go on the press is this place was approved by the community board. This place was, you know, anything that can really make this ink enhance the story. It goes out, and it unfortunately damages the work of the community board, where we're struggling and try to make sure that folks respect the work the community board does. So informing us about something that's happened and that someone is in mediation, I don't see how that could be an issue. I just think that we need to find ways that we are, as all partners, are not adversarial and are speaking to each other and letting people know when we are engaged, especially with businesses that are in the district. And I'll say no more about this. Susan, you're muted.
Thank you. I wanted to just give a last chance if anyone else had a question before we left. No more questions? Okay, well, thank you very much for a very informative meeting. And I think in the beginning, the chat wasn't going to everybody, so I've copied it, and I'm going to send it to everybody on the original list, the links of everyone on the original list. Okay, thank you again.
Thank you, Susan. And thank you, everybody, for the questions. Really appreciate it.
Thank you.
Thank you, everyone.
Thank you.
Thank you. Have a good one.
Take care.
Thank you, Susan.